Imagine, just for a second, that you are investing heavily in this massive global corporation.
Right.
The hype surrounding this enterprise is just, well, it's absolutely unreal. Everyone is talking about it. The stock price is totally soaring, and this company is paying out these massive, unbelievable dividends to its shareholders.
Yeah, you feel like a genius.
Exactly. You feel like an absolute financial genius for getting in early. But behind closed doors, like deep in the accounting department, the reality is terrifying. The company is secretly drowning in a massive ocean of debt.
Oh, wow.
Yeah. They are essentially borrowing money at these exorbitant rates just to keep paying you those dividends, entirely to keep up appearances and, prevent a total panic.
It is the ultimate corporate house of cards. I mean,
Yes.
a financial illusion built entirely on pure speculation, deeply flawed intelligence, and frankly, just institutional denial.
And today's deep dive is all about what happens when that exact house of cards comes crashing down. And we're not talking about the 21st century, but the 1760s and 70s.
Right, the East India Company.
Exactly. We're exploring the East India Company's period of delirium and how the British Parliament's desperate attempt to fix this profoundly corrupt system through something called the Regulating Act of 1773 actually accidentally ignited an epic, chaotic, and literal turf war between the government and the judiciary in Bengal.
It's just a wild story of unintended consequences operating on a massive imperial scale.
Yeah.
You have this profit-driven corporation suddenly trying to act like a sovereign government
Yeah.
and an actual government trying to rein in that corporation.
Yeah.
And honestly, neither entity has any real idea how to manage the legal and cultural complexities of the Indian subcontinent.
It reminds me of a very modern scenario, actually. It's like a too-big-to-fail tech monopoly today, paying out these massive executive bonuses with entirely borrowed money, acting like they own the world,
Right.
and ultimately triggering this messy, flailing government bailout because they've woven themselves so deeply into the fabric of the global economy. Okay, let's unpack this. How did the East India Company get into this delirium in the first place?
Well, the catalyst was a massive disconnect between perception and reality back in London. So in 1765, the East India Company acquired the right to collect land revenues in Bengal.
Okay.
And back in Britain, the public and the company's shareholders, who were known as the proprietors, they developed this vastly inflated conception of what that actually meant.
They thought they were instantly rich.
Exactly. They believed the wealth flowing out of India was simply inexhaustible. And that sparked an absolute frenzy in the stock market in 1766. At one point, East India stock prices skyrocketed by as much as 263%.
Wait, 263%?
Yeah, it was madness.
That is just a classic bubble. I mean, people were trading on pure fantasy at that point.
Fantasy that they basically demanded be made real. The proprietors, whose main interest was really just buying and selling the stock at a profit, were entirely indifferent to the actual mechanical realities of running an empire.
Right, they just wanted the payout.
Exactly. They didn't care that the company's military expenses in India were astronomical, or that they were secretly burying themselves in debt just to keep the lights on. They simply formed alliances with stockbrokers and political opposition groups to force a vote, granting themselves a massive 12.5% dividend.
Just voting themselves free money while the ship is actively taking on water? That's incredible.
And to protect that flow of money, they used their voting power to force the company directors to drop ongoing prosecutions against highly corrupt company servants.
Oh, wow, so they just let them off the hook.
Completely. These were men who had been extorting local populations and taking lavish illegal presents in Bengal. The proprietors essentially voted to legalize their own executives' corruption just to keep the dividends rolling in.
That is wild.
And what's fascinating here is how this pure, unadulterated greed by the proprietors directly necessitated the creation of an entirely new government structure in India.
Because the British government had to step in.
Right. The British Parliament realized this corporation was wildly out of control and had to step in before it crashed the entire British economy.
Wait, I have to push back on that framing a little bit, though.
Oh, sure.
Because Parliament intervenes in 1767 and 1769. They cap the dividends, sure, but they also demand a £400,000 annual payment directly to the Exchequer, which was the British government's national treasury.
Yeah, they did.
So Parliament demanded a massive fixed cut of the profits for the national treasury while the company was secretly going broke. Weren't the politicians just as greedy as the stockbrokers?
Well, the British government absolutely saw the East India Company as a bottomless cash cow.
Yeah.
They wanted their cut of this perceived Oriental wealth to pay off national debts, so they passed acts establishing the nation's right to participate in the company's acquisitions.
So they were definitely complicit.
Oh, absolutely. But this shared national delusion finally shattered in 1772. The company became so profoundly embarrassed by its mounting, unmanageable debt that the chairman actually had to go to the British minister and beg the public for a massive bailout.
Oh, no.
Yeah, a loan of £1 million just to avoid immediate bankruptcy.
That is the ultimate corporate walk of shame. I mean, going to the government and begging for £1 million in the 1770s.
And that massive humiliation forced the government's hand. They realized they couldn't just take a passive cut of the profits anymore. They had to actively regulate this beast.
They had to step up.
Right. They had to stop the local corruption in India that was draining the revenues. And they had to bring the company's road management under the strict control of the ministers in Westminster.
Which brings us to Parliament's grand solution, the Regulating Act of 1773.
Yes, the infamous act.
And based on what happens next, solution is doing a monumental amount of heavy lifting here.
It really is.
So let's look at how Parliament structured this. They created a new executive government in India, a governor-general and 4 councillors. And to make sure they wouldn't be tempted by local corruption, they gave them astronomical salaries. The governor-general was paid £25,000 a year, and the councillors got £8,000 each.
To put that in perspective, £25,000 in 1773 was unimaginable wealth.
Yeah, it's basically lottery money.
It was an anti-corruption bribe from the government, essentially saying, we will make you richer than kings so you don't feel the need to steal.
And alongside this executive branch, the act created a Supreme Court of Judicature. This had a chief justice paid £8,000 and 3 judges paid £6,000 each. And they were completely forbidden from engaging in any commercial pursuits or taking presents.
Right. The logic was to bring in professional, independent men of the law, king's judges, to keep the company's profit-driven servants in check.
Makes sense on paper.
On paper, sure. But the drafting of this legislation contained a fatal flaw regarding jurisdiction. The act gave the governor-general the management of territorial acquisitions and revenues.
Okay, so they collect the taxes.
Exactly. That means they are in charge of collecting taxes and managing the land. But simultaneously, it gave the Supreme Court jurisdiction over any of His Majesty's subjects or anyone who was employed by the company.
Which sets up a massive collision.
A huge one.
The historian James Mill was absolutely scathing about this specific phrasing. He pointed out that Parliament created 2 independent, wildly powerful rival branches of power in India, the Supreme Council and the Supreme Court, but completely failed to draw a boundary between them.
They drew no lines at all.
The law didn't clarify if the management of the revenue was exempt from the jurisdiction of the court. So I have to ask, were the drafters of this act really that legally blind, or was this intentional ambiguity? Did they just not know how to write a functioning constitution?
Well, the drafters were brilliant legal minds, which means the ambiguity was largely an intentional avoidance of a massive political and geopolitical headache.
Here's where it gets really interesting, because in writing this law, the British Parliament deliberately avoided declaring the King of England as the sovereign of Bengal. They intentionally left the ultimate ownership of the territory completely vague.
And that is the crux of the entire disaster. If Parliament formally declared the British king as the sovereign of Bengal, they would have to officially annex the territory.
Which is a huge step.
Massive. That would mean dealing directly with the Mughal emperor, who was still technically the recognized sovereign, which could, trigger international wars.
Right.
Furthermore, it would force them to figure out exactly how English common law applied to millions of native inhabitants who had their own complex legal systems.
Yeah.
Parliament didn't want that financial or geopolitical responsibility.
They just wanted the money.
Exactly. They just wanted to graft a British judicial band-aid onto the existing administration carried on by the company.
So the act was completely silent on who actually owned the country. The judges were technically only supposed to have jurisdiction over European and British subjects or native dependents working for them.
Right.
But in reality, the company's administration was so vast and tangled that it was impossible to tell who was truly employed by them and who wasn't. Okay, so let's look at what happens when this incredibly vague legal theory hits the actual dusty ground in Bengal. The turf war begins. Justice versus revenue.
To fully grasp the ensuing chaos, you really have to look at the old system. Before the Supreme Court arrived, the company servants acted as the final judges in their own causes.
Which sounds like a terrible idea.
It was. If a local revenue collector was accused of violent extortion, his own corporate counsel would investigate it. Obviously, this was deeply corrupt and led to terrible abuses. The new Supreme Court was supposed to be this awe-inspiring, independent instrument to terrorize these corrupt officials and stop the oppression.
Right, but the Supreme Court judges arrive in Calcutta, and they don't just go after British executives. They start issuing legal summons to the zemindars. These are the local aristocratic landowners and revenue farmers who are responsible for actually collecting the taxes out in the provinces.
And this is where the cultural and legal collision becomes devastating for the local population.
Yep.
The historian James Mill paints an incredibly dark picture of the daily reality here.
Yeah, sounds brutal.
It really was. You have these zemindars, men of extremely high rank, caste, and status in their communities. Suddenly, because of a minor civil debt claim filed by a rival, they were being arrested by heavily armed court officers and dragged from their families.
Wow.
Sometimes they were forced to travel distances as great as 500 miles just to reach Calcutta.
500 miles in the 1770s through the Bengal River Delta. That's not a quick road trip. That is a massive, arduous, disease-ridden journey that could take weeks or months.
And the humiliation was profound. When they finally arrived in Calcutta, they were thrust into a completely alien legal universe. They couldn't understand English common law. The procedural delays were enormous.
Because it's a completely foreign system to them.
Right. And if they couldn't afford the exorbitant bail set by the English judges, these local aristocrats were thrown into loathsome, unsanitary dungeons for months before their case was even heard. To a high-caste landowner, being publicly arrested and imprisoned like this completely destroyed their local prestige.
Which means when they eventually went back home, no one would pay them taxes anyway because their authority was totally shattered.
Exactly.
But beyond the human suffering, this completely broke the mechanics of the tax system. Local defaulters, people who just didn't want to pay their taxes, suddenly realized they could use this complicated English legal system as a weapon. They started suing the revenue collectors for using any coercive methods. The defaulter would get a writ of habeas corpus from the Supreme Court.
And that writ is crucial here. Habeas corpus is a fundamental English legal protection against unlawful imprisonment. But in this context, it physically required the accused tax collector to drop everything and be brought before a judge in Calcutta to justify their actions.
So by simply filing for that writ, a local defaulter could yank the tax collector entirely out of their district, bringing all revenue collection in that region to a screeching halt.
If we connect this to the bigger picture, the entire British colonial project, the administration, the military, the dividends back in London, it all relied exclusively on the uninterrupted flow of this land revenue.
The money had to keep moving.
Exactly. The traditional method of collecting taxes in an agrarian society had to be somewhat swift and summary. You collect right after the harvest.
Yep.
If you delay, the money is spent or hidden. The local method relied on strict coercion, like placing a guard over defaulters' house until they paid. But now, the moment a collector tried to do that, they were hit with a writ from Calcutta. The collection of revenue was completely paralyzed because every company's servant was terrified of being sued and dragged to a dungeon by the judges.
It's like local middle management suddenly being audited by a Supreme Court justice who speaks a completely different legal language and doesn't recognize their corporate authority at all. The entire assembly line just stops.
That's a great way to put it.
Because this legal ambiguity was so unworkable, you start seeing these localized eruptions of power across Bengal. We have these judges who are just flexing their authority in the most extreme ways.
The Supreme Court judges, particularly a man named Justice Lemaistre, were entirely uncompromising in their application of English law. A prime example is the case of the Rani of Burdwan.
Oh, this case is intense.
It is. She was a wealthy aristocratic widow. The local Provincial Council of Revenue suspected her of hiding money, so they basically used military force to confine her, violating her zenana, which are the private, sacred inner apartments reserved exclusively for women.
And culturally speaking, breaching the Zenan is a profound, unforgivable violation of privacy and honor.
Absolutely. The Supreme Court immediately intervened. Justice Lemaistre wrote a furious, blistering letter to the Provincial Council, tearing them apart for using what he called the orders of despotic power. He famously declared from the bench that he was bound by English law to give the exact same measure of justice to the lowest peasant as he would to this high-ranking Rani.
Now, on paper, That sounds incredibly noble. Equality before the law is a foundational concept.
Hmm.
But let me push back a little here.
Sure.
Were judges like Lemaistre genuinely trying to protect the locals from the company's rapacious greed, or were they just power tripping? Did they just enjoy humiliating these incredibly wealthy corporate executives?
Well, that specific tension is debated heavily by legal historians. Sir J.F. Stephen, a later legal mind analyzing this period, argued that Lemaistre's letter was incredibly arrogant and full of silly violence.
Silly violence, that's a great phrase.
The judges were definitely deeply invested in the moral superiority of English common law and genuinely believed they were stopping tyrannical abuses. But their total disregard for the practical realities of the local government was astonishing. Take the case of Sarup Chand.
Oh, the Sarup Chand incident is unbelievable.
It really is. Sarup Chand was the official cash keeper for the Dhaka Council, and he was arrested by the company for being massively in debt on his revenue payments. He immediately sued for a writ of habeas corpus.
Of course he did.
When the company's attorney tried to argue in court that the provincial council had the legal right to imprison him for debt, Justice Lemaistre openly mocked the government's attorney. He asked, "Who are the provincial chief and council of Dhaka?" He declared from the bench that they were not a legally recognized corporation and that the chief might as well say he was commanded by the king of the fairies.
The king of the fairies. He's sitting on a Supreme Court bench, totally delegitimizing the very government that collects the tax money to pay his own £6,000 salary.
He went even further than that, actually. He completely refused to acknowledge that these revenue councils had any legal right to exist, issue orders, or enforce the law whatsoever.
And it wasn't just rhetorical insults either. In 1776, the judges went directly after the company's secret records. The Chief Justice literally compelled a company secretary under oath to reveal the names of the council members who had voted to keep certain government transactions hidden from the court. So what does this all mean? When the judiciary stops recognizing the basic legitimacy of the executive and the executive is terrified of the judiciary, where does it end?
It ends in total administrative warfare. The Governor General and his council realized they were entirely losing control of the country. The legal skirmishes escalated until the government literally went to war with its own judiciary.
Wow.
The climax of this institutional meltdown begins with something called the Patna Cause, which ran from 1777 to 1779.
This one is incredibly dark. It starts simply enough, just as a messy inheritance dispute over the estate of a wealthy military adventurer.
Right. A widow and a nephew were fiercely fighting over the property. The local provincial council did what was customary for them to avoid complex local legal theology. They handed the investigation over to the local Mohammedan law officers, known as the Qazi and the Muftis.
Which was standard practice.
Exactly. These native officers concluded that the widow's documents were forged and recommended dividing the property. When the widow refused to comply, the council basically put her under armed guard to force the division.
But she knows exactly how to game the new system. She bypasses the local council entirely and takes her case straight to the Supreme Court in Calcutta. She sues the Qazi and the Muftis personally for assault and false imprisonment.
And the Supreme Court completely decimates the local officers. They ruled that the provincial council had absolutely no right to delegate judicial powers to these local officers. They applied a rigid English legal maxim, delegatus non potest delegar,
Which essentially means that because the provincial council had already been delegated power by the East India Company, they legally could not pass that power down again to the local Mohammedan law officers.
precisely the logic they used. Because of that technicality, the Chief Justice decided the local officers had acted entirely illegally. He fined them a staggering, ruinous 300,000 rupees.
That is life-destroying money. And then they dragged these local law officers away to jail in Calcutta. The Qazi, who was an incredibly respected and aged community figure, actually died on the brutal journey there.
It was a bureaucratic tragedy that highlighted the absolute failure of this hybrid system. Now, the court did expose that the local revenue councils were grossly careless. I mean, they didn't even keep separate books for their actions as revenue collectors versus their actions as judges.
So they were disorganized.
Very. But the court's strict, uncompromising remedy was so heavy-handed it destroyed the local administration of justice entirely. No local officer would ever dare enforce a ruling again.
Which brings us to the absolute breaking point. The Kasi Jura cause in 1779. This is where the tension goes from legal threats and technicalities to actual physical violence.
This is the moment the entire colonial system snaps. A wealthy businessman in Calcutta tried to sue the Raja of Kasijura in the Supreme Court for a massive outstanding debt.
Okay.
The Raja was a powerful zemindar, heavily involved in collecting revenues for the company. This time, the Governor-General decided he had enough. Fortified by advice from the government's Advocate General, who was the colonial government's top legal advisor, the Governor-General instructed the Raja to completely ignore the Supreme Court's legal process.
Wait, the executive branch is literally issuing orders to its citizens to ignore the judicial branch.
Exactly. And the Supreme Court, furious at having its authority ignored, resorted to extreme, unprecedented measures.
What do they do?
The sheriff of Calcutta gathered a makeshift force of 60 or 70 men, mostly drunken sailors they just rounded up from the ships in the harbor, armed them, and marched them out to Kasijura to physically seize the Raja.
I am just picturing this. A mob of heavily armed rogue sailors marching through the Bengal countryside to arrest a local king on the orders of a judge. It is pure, unadulterated chaos.
And they actually reached the estate. They violently seized the Raja, broke into his zenana, physically outraged the sanctity of his family idol, and took him prisoner.
But the Governor-General doesn't just write a stern letter of protest this time, right?
Oh, no. The Governor-General and his council deployed actual military troops. Colonel Amiri was sent with a detachment of professional military forces to intercept the sheriff's men. They surrounded the sailors on their return journey to Calcutta, took the sheriff's men captive, and completely stripped them of their prisoner.
That is unbelievable.
This raises an important question. How can any government possibly function or claim any sort of legitimacy when its two highest constitutional powers are physically deploying troops to arrest each other's agents in the street?
It can't. I mean, it is the textbook definition of a failed state, orchestrated entirely by a profit-hungry corporation and a poorly drafted law. You have the executive branch using the military to ambush the judicial branch of the exact same government.
It created a state of wild excitement and absolute terror in Calcutta. Petitions were flying back to Parliament in London. People genuinely thought that if the judges weren't packed onto a ship and sent home immediately, the entire British Empire in India would collapse into civil war.
So how does Parliament finally clean up this monumental, embarrassing mess they created?
In 1781, Parliament was forced to pass an amending act. And they made a very clear, very cynical, and highly pragmatic choice. The new law explicitly dictated that no person should be subject to the Supreme Court's jurisdiction solely on the ground of being a revenue farmer or a zemindar.
So they carved out a massive legal exception entirely for the tax collectors.
The British Empire officially prioritized the efficiency of tax extraction over extending English legal protections to the locals. They realized that you cannot fund an empire or pay out massive corporate dividends if the people collecting the money are constantly terrified of being sued for their coercive methods.
Right. The money comes first.
The East India Company's ability to extract wealth was forcefully protected, and the Supreme Court was put back into a much smaller, highly restricted box.
It is an incredible historical journey. We started with the East India Company's stock market delirium in the 1760s, where pure greed blinded everyone to a mounting debt crisis. We saw Parliament try to step in with the incredibly vague Regulating Act of 1773, intentionally ignoring the question of sovereignty and accidentally setting up two rival powers.
Yeah.
And we watched that legal ambiguity devolve into a literal armed standoff between judges sending rogue sailors and executives deploying the military.
It perfectly illustrates the intense danger of treating a profit-driven corporation like a sovereign state, especially without putting in the meticulous, careful legal frameworks required to manage the actual realities of the people living there.
And it leaves you with something really important to think about today. If an 18th century corporation taking on government-like powers required this much messy, destructive, and violent regulation just to bring to heel, how prepared are our modern global legal systems to rein in today's multinational megacorporations if they begin providing basic civil infrastructure or acting as pseudo-sovereign entities in the digital age? It's definitely something to chew on. Thanks for joining us on this deep dive, and we'll catch you on the next one.